It is my pleasure to introduce our next session, which will cover Department of Education rulemaking. We are thrilled to have Judge Michael Brennan of the U.S. Court of Appeals for the 7th Circuit joining us as our moderator. Thank you for being here.
Thank you. Good afternoon, everyone. Good afternoon, everyone. We are the Administrative Law panel and beyond. Welcome to this third plenary session. You can tell from the quote in the session's title, which comes from Justice Scalia's decision in Whitman versus American Trucking. This has become an area of great debate and deeper discussion. Specifically, Justice Scalia said, Congress, we have held, does not alter the fundamental details of a regulatory scheme in vague terms or ancillary provisions. It does not, one might say, hide elephants in mouse holes. You're going to hear a lot today about Biden versus Nebraska. And if you take a real deep dive on that case, you'll notice that the early quotes in the majority opinion from Chief Justice Roberts include quotes from the Whitman case, although not this particular quote. A little bit of background, and then we'll go to brief introductions of our panelists, and then we'll open up into a couple of round-robin sessions. June 30th of last year, the Supreme Court ruled in Nebraska versus Biden that the president had overstepped his authority when he engaged in executive action using this 2003 law, the HEROES Act, to forgive up to $20,000 in student debt per person. Hours later, the president announced he would instead pursue debt relief under the Higher Education Act of 1965. The HEROES Act gave authority to the Secretary of Education to waive or modify loan terms, while the Higher Education Act permits the administration to compromise loans and forgive them in specific circumstances. The executive action that was struck down by the Supreme Court in Biden versus Nebraska and the new proposal, which is currently going through negotiated rulemaking, provide a number of threads for our discussion today. Was there an abuse of the emergency powers in the original executive action under the HEROES Act? What about upcoming Education Department negotiated rulemaking? Does that exceed statutory authority, or is it reasoned policy making within congressional authorization? Can the statutory basis for the new proposal be found in the Higher Education Act? And what about standing to challenge such an action? These various threads also implicate a number of both policy and legal steps. The major questions doctrine from West Virginia versus EPA, the Education Department's loan discharge regulations, which were enjoined by the Fifth Circuit just last month. The Education Department administratively forgave $39 billion in federal student loans pursuant to a one-time account adjustment, which the Cato Institute then challenged in the Federal District Court in Michigan, but that was dismissed for lack of standing. So we've got these general topics. We've got some more particular and specific legal and policy questions. We've got a distinguished panel, Jed Sugarman, professor of law, and Joseph Lipsett, scholar at Boston University Law School, Christian Corrigan, who is the Solicitor General of the state of Montana, Farnaz Thompson, a partner at the McGuire Woods law firm, Lene Erickson, Senior Vice President for Social Policy at in Education and Politics at the Third Way, and Jennifer Braceras, the Director of the Independent Women's Law Center at the Independent Women's Forum. Our discussion is going to proceed that each panelist is going to have 6 minutes to give a thesis statement. Then each panelist will have 9 minutes to respond to each other's remarks in a roundtable fashion, and we'll reserve 15 minutes at the end for questions from the audience. We'll start with Professor Sugarman.
First of all, thank you so much for having me here. Part of it, it's Marshall McLuhan, wrote, and this is also in a Woody Allen movie, that sometimes the medium is the message, and I think the fact that I was invited here is part of, I think, says something about the Federal Society's commitment to debate, and the fact that I'm here says something about my experience about teaching administrative law circa 2020 to 2023. So what I'll say first is, let me give an overview of the substance. I have 3 main points. I will be presenting this back here in DC at the Cato Institute because I published, coming out of an amicus brief I filed in Biden versus Nebraska against the Biden administration on behalf of the respondents, that, and to answer the judge's questions, that it was, that the Biden student debt cancellation was an abuse of executive power. I will say something about that I think the upcoming policies are contestable, but I think there are hints in the Biden versus Nebraska, specifically on page 2 and 3 of the slip opinion, and I'll say more about that, where it's more than dicta, but indicates where the Supreme Court is going and why I have concerns about that. And on the third question about standing, I have a lot more you can read in the Cato Supreme Court review on this, but I think what comes next, if one wanted to contest, and I encourage this development, I think the way to read Biden versus Nebraska is what I call the new state standing. It's the only way to understand how there's a coherent view of, let's say, Scalia's opinion in Lujan and Spokio and TransUnion, and how to square that with what the majority ruled. But before I get there, I do want to say a word. Justice Kagan, before she was on the Supreme Court, came to a Federal Society event and said, just to be clear, you are not my people. And then she went ahead and endorsed textualism, and they got a standing ovation. I'm not here to say that you are not my people. In fact, I think many of you are my people, and I hope you are. I'm not here to endorse textualism, and nor do I think at the end of this talk will I get a standing ovation. And I also don't think I'll get a nomination to the Supreme Court anytime soon by any party. So that ship has sailed a long time ago. But let me just I asked the judge to give me the privilege of saying a word or two about this context of what I've heard today and share sort of from the academy what I'm seeing. And so I wasn't going to make this, I really boiled things down to a 6-minute concise distillation of these 3 substantive points. But I was moved this morning in reflecting about the role that COVID played while we were teaching in law schools, and also my experience in March of 2020 as the shutdowns happened, of having 3 teenagers in my house, and also occupying my Wi-Fi bandwidth and my emotional bandwidth. All at the same time. And so a couple of reflections. I mean, I'm a lifelong Democrat. I'm not about to change parties anytime soon. And I spent way too much time on it, watching and being on MSNBC during the Trump years. But I'm also an originalist. And I'm not a textualist. I think of it as a consistent contextualism. And I go to ACS events and argue and defend originalism. And not just progressive originalism, but also when originalism doesn't come up with the results that, I don't know, let's say Professor Balkin wants to suggest that originalism. I also assign Scalia in my administrative law classes, and in my evaluations, I often get feedback, Sugarman assigns too much Scalia. I assign a matter of interpretation, and I defend it on both, on the originalism grounds that I agree with, and on the textualism grounds that I play devil's advocate on. I will also say that, I'll tell one story, but that story has led me to volunteer now that I've arrived at BU, and actually I have the appointment in hand. I've reached out to say that I'd like to be another faculty advisor, in addition to my wonderful colleagues Gary Lawson and Kathy Zeiler, a faculty advisor to the Federal Society chapter. I say that all as some version of a progressive, it depends on my mood and who I've last argued with, of whether I'm a progressive Democrat or a conservative Democrat. I think I've decided that I'm a rule of law Democrat, or a constitutional Democrat. And I put the emphasis on rule of law first and constitutional first, especially in my experiences teaching and arguing with the left about the Biden student debt cancellation, which I do regard as lawless. I want to give one anecdote, 2 brief anecdotes. One is when I teach the major question doctrine, I defend it. I'll say briefly about why I defend it. But when I teach OSHA versus NFIB, when I teach Whitman, I cite and quote elephants and mouseholes. I teach OSHA versus NFIB on the vax mandate as rightly decided, the eviction moratorium as rightly decided. And I wrote an amicus brief that I taught, hoping that the Roberts Court would reach that right result that it did. What I say in the Cato article is that it was the right result, but for the wrong reasons, or actually right result and what reasons. It's hard to tell, but I'll explain a bit more. But as I want to tell one anecdote from teaching, that when I teach this material recently, and I won't say which class, and I won't identify any particular student, but I asked students to, I get a lot of pushback about COVID as an emergency and a left-wing defense of emergency powers. And I asked my students, when I was getting a lot of pushback on my take on these cases, I just spur of the moment said, well, how many people, when you were in the spring of 2020, wherever you were living, did you find that the locality on COVID was not restrictive enough? And immediately half the class put their hands up in the air. Then I watched other students look around and see how many hands in the air, and they then made sure to put their hands up next. And before I knew it, 80% of the room thought that their locality was not restrictive enough. Now keep in mind, I've been teaching in two very blue northeastern schools, and many of the students probably came from around those areas, and yet even those blue areas for many students was not restrictive enough. So then I paused and I said, well, the students who felt like their localities were too restrictive, would you put up your hand? One student puts up his hand, and then I see several students sort of put up their hands, look around, and put their hands back down. Okay, keeping score there in my classroom, where I have intentionally been giving voice to making sure that conservative voices, moderate voices, as well as progressive voices have a space. They're not looking to show me balance. They're more interested in what their classmates think. And heaven forbid they say anything that might not comport with that. So in class, I challenge this, but then I realized, you know what I'm going to do? I do a handout, an anonymous handout with a set of questions that review the material in our Article 2, I call it my sort of Article 2 unit of admin, and ask questions of cost-benefit analysis. But I added this question anonymously, the same question. Did you live in a locality that was too restrictive or not restrictive enough? Guess what? By the time I got it back, the split anonymously was 60-40. Now, 60% thought their locality was not restrictive enough, but 40% anonymously would say what they would not say in class. And I didn't say anything at the time, but I waited until my last class about the importance of independent thinking. And I think there is a crisis in higher education, and a crisis that, frankly, I think it's hard to manage right now during COVID, but and I think my colleagues understandably have been managing COVID in a way that is sacrificing some of that pushback. But I'm hoping that we can, just as I hope are returning to normalcy, that we as teachers can also return to an important pushback for critical thinking. Now, that's on the one hand. On the one hand, this morning, when I asked a question about administrative law and the Republican Guarantee Clause, I don't know who said it, but within earshot, I heard someone respond to my question by saying, "That's a dumb question." And I heard a response, and I won't get into it, but I am here because I'm interested in dialogue. I'm also interested in civility. Okay? Now, I don't know who that person was. I will be around for cocktails, and I would be delighted to tell you about my take on the Republican Guarantee Clause and why I'm writing a chapter in my book about it, about the presidency. And I would be delighted to talk to whoever that person is about your vantage point and to engage in dialogue. That's why I'm here. So now I think I've used up more of my time than I said I would, but again, the medium is the message. So here is the bottom line about my read on Biden versus Nebraska. And this is to encourage, I think the first point is, and I think that there are some state AGs who might be interested in hearing some of this, that I think the first point is the only way to understand the standing part of Chief Justice Roberts' opinion is that it is the new state standing. Let me flesh that a little bit more. Kagan articulates the challenge to the state to how Missouri has standing for Mohela, and Chief Justice Roberts doesn't give a clear answer to Kagan. Why? Because even if Mohela, let's say Mohela is injured, let's grant that, there are too many questions about how Mohela's injury in the case could then impact the state of Missouri. If 100,000 Missouri voters, Missouri citizens, were plaintiffs in the case making the same arguments, it would have been dismissed as taxpayer standing. The only way to understand how the state of Missouri can make those same substantive claims and have standing is because of its status as a state. Otherwise, Missouri has the same problems when it comes to, as I said, Lujan and Scalia's opinion about concrete and imminent injuries, or the updating of those cases in Spokio and TransUnion that require not just speculation about future injuries, but a strong probability. So, okay, so I can say more about that later, but if the Biden administration, even if I think the Biden administration has a statutory grounds to do so, I think this line of cases needs to be pushed. And I think, let me also say one more thing. I'm disappointed that the left, I'm disappointed that Kagan, Sotomayor, and Jackson didn't write anything to say, hey, what's going on here? Oh, wait, our allies on the left wrote Massachusetts versus EPA, where they suddenly disappeared on that case. Well, both sides are being convenient on standing. Okay, that was point number one. Quickly on point number two, and I'll be really quick on this. 3 cheers for the major question doctrine. The problem is that there are 4 questions. This is not a Passover Seder, but there are four questions that come up with the major question doctrine. One is no Chevron. I'm all in on that. Right? Loper Bright, I may not be, yes, Loper Bright should be the opportunity for the court to overturn Chevron, which was wrongly decided the day it was decided. I tell my students about when they worry about Chevron, I say, worry less, skid more. My administrative law nerds will appreciate that joke. No Chevron. I think the major question doctrine is purposive as opposed to textualist. That's good. And it's also a clear statement rule. Good. Here's the problem with the major question doctrine in the last year from West Virginia versus EPA and Biden versus Nebraska. It's not just a clear statement rule, but it's a clear and specific statement rule. Here's the problem with this, and it comes up as the be careful what you wish for. Because when you have a clear and specific statement rule, the problem becomes when on the use of emergency powers. When Congress has delegated emergency powers to the president, it has done so too vaguely and too ambiguously. That's Congress's fault. But the problem is you also have emergencies in the world. So my solution is not this clear and specific statement rule is great if you don't like the other side's abuse of an emergency power. But what happens? It is September 13th. We are 2 days after the anniversary of September 11th. My concern is that in the next emergency, the next terrorist crisis, the next real crisis where an administration wants to rely on ambiguous emergency powers, this line of cases mean that anything an administration wants to do has to not just be clearly delegated, but clearly and specifically delegated, and that is going to handicap presidents from responding to emergencies. Okay, that's point number 2. Very briefly, my point number. I'll see if point number 3 comes up in Q&A. 2 points.
Thank you. We'll now move to General Corrigan.
Well, thanks to the Defense of Freedom Institute and the Federal Society for hosting this and for inviting me. It's really an honor to be up here with all these exceptional individuals and a part of this conference with so many other exceptional individuals. I'm going to talk today about 2 things. The first is everyone's favorite topic, standing, as well as the major questions doctrine and what that might mean for Title IX. But piggybacking off what Professor Sugarman said, not just any standing, state standing, and I don't think it will shock anyone that I'm actually in somewhat agreement with the professor and agree that states shouldn't be normal litigants for purposes of Article III injuries. The idea, one of the points he makes in his article is the idea that something could qualify, as a major question, but would be insulated from review because no one's going to have standing to challenge it is actually troubling. And I think like the major questions doctrine, state standing sort of serves as a check on both executive power and federal power in general. But part of this is complicated by the fact that the court's state standing doctrine is an absolute mess. Part of it's because you likely don't have 5 justices that agree in any configuration on the parameters. Nobody can make up their mind on what to do about Massachusetts v. EPA. Justice Gorsuch's concurrence in United States v. Texas points this out and asks a lot of very thought-provoking questions that the court just doesn't want to address at this point. But looking at Biden v. Nebraska, the issue was whether the state of Missouri could bring a suit on behalf of Mohela, a nonprofit corporation that was created by the state, but that it was its own legally distinct entity. And I agree that the Chief Justice sort of papers over the analysis, and the question all along was, well, why isn't Mohela here? Why haven't they brought their their lawsuit. And it was relatively clear that Mohela would suffer financial loss. I mean, this was obviously on an emergency posture, but it was pretty likely that Mohela was going to see decreased revenues. But the Missouri legislature had created this sort of unique entity. And as a matter of state law, as the professor said, there was a debate between the majority and the dissent over whether the AG, on behalf of the state of Missouri, could bring a suit for an injury suffered by Mohela when Mohela wasn't a party. So at some level, I don't think that Missouri's standing to bring a claim on behalf of Mohela was much different than, say, Washington and Minnesota's standing to challenge the Trump administration's executive orders on immigration on behalf of the state universities. In some instances, this turns on a very specific question of state law. But I think that the state standing debate in Biden v. Nebraska loses sort of the unique aspects of state law and how the executive branches are structured. The Attorney General in most states acts on behalf of the state, and he has two roles. The first is acting as the Department of Justice to defend state agencies when they're sued over whether it's a constitutional lawsuit or anything else like that. But the AG also has another role where he functions on behalf of the state, and particularly in Montana, and files a lawsuit to challenge on behalf of the state, which is more of an umbrella entity. And for example, in Montana, in a slightly different context, if you sue a state agency, or if you file a lawsuit where you either allege that a statute's unconstitutional or raise a defense that the statute's unconstitutional, you have to provide notice to the Office of the Attorney General, and we're granted mandatory intervention to defend the state statute. And so under Montana law and other laws of many other states, it sort of implicitly recognizes that the state as a whole has an interest in seeing its laws be defended, which I also think translate to sort of this state standing theory that the Attorney General and the state itself has an interest in redressing an injury to any entity that's created by the state and the legislature. So I think absent some sort of unique element of state law, I think my view is generally that, anytime a state instrumentality suffers an injury, the state itself should be able to sue. Now, I think a really easy fix to a lot of this would be for state legislatures to just pass statutes, making sure that the state attorney general has as much authority as possible to assert rights on behalf of state instrumentalities. Certainly there might be unique quirks in state constitutions. I can think of a few in the state of Montana that might come up. But in general, the court has been fairly deferential to state law when deciding whether the attorney general has the authority on behalf of that entity. Okay. So now, switching gears just a little bit to the major questions doctrine. I think regardless of what interpretive school you come from, textualism or otherwise, the major questions doctrine is itself a limitation on executive power. So if you're a fan of executive power, it's definitely not your cup of tea. But I think it's, as the professor pointed out, it's one of those things that what's good for one party in power is also going to be good, or what's not good for one party in the power is also not going to be good for the next party in power. So there's sort of two questions as it relates to the major questions doctrine and the administration's proposed rules on Title IX. And so the first is, does the major questions doctrine apply to a proposed rule like Title IX? And if so, what does that mean? In my time, I'm going to basically just address the first question about whether the major questions doctrine applies after Biden v. Nebraska, and then we can get into the merits later on. But in Biden v. Nebraska, the Chief Justice, interestingly enough, is responding to the government's argument about the purpose of the HEROES Act, and that's where he goes and cites West Virginia v. EPA. And he says, well, we're going to really look, he restates the test and says we're going to look at more or less three factors. And the first is going to be the history and breadth of the authority that the agency's asserted, as well as the economic and political significance of the issue. And I think on the first prong there for the history and breadth of the authority, I think many of the merits arguments about why Title IX specifically related to why Title IX should or shouldn't cover sex as binary, or only cover sex as binary, I think addresses most of that. But I think what's important is the court is looking at, are you taking an established statute and sort of claiming some type of new sweeping power? And I think it was alluded to earlier, whether it's the student loan case, the eviction moratorium, the OSHA vaccine mandate, that is itself the court looking to see if we're trying to stuff an elephant into a mouse hole. And I know that I'm over my time, so I will actually cover the rest on my next round. But suffice it to say, I do think that it satisfies the economic and political significance test as well.
Excellent. Thank you. Let's move to Farnaz.
Good afternoon. My name is Farnaz Thompson. Johnson, and I'll be talking about a very sexy topic, sexier than even Title IX. I'm going to take us back to federal student loans. Are you able to hear me? Are you able to hear me now? Well, you missed out on my topic about the sexiest topic for this panel, which is federal student loans. So we have $1.6 trillion in federal student loans, which is approximately 9.5% of the national debt. And when I was at the Federal Department of Education, what I didn't realize is that the Federal Department of Education is one of the largest banks, or at least one of the largest lending institutions. But there are very few people at the Federal Department of Education, including federal student aid, that have a financial background or that are CPAs, and that's including me, and I served in the General Counsel's office. Remember that, because the Supreme Court in West Virginia versus EPA did state that in giving certain powers to an agency, the court would look at whether that agency actually has the capability or that policy expertise. And I would submit that there's not a ton of people at the Federal Department of Education with a deep bench in federal student loans and lending. So with that, I would like to address a little-known scheme called the Borrower Defense to Repayment Scheme, which doesn't actually apply in emergency situations, so I'd be very curious to hear Professor Sugarman's thoughts. But this scheme allows the Federal Department of Education, or the department thinks it allows it, to forgive billions of dollars of loans. And while we're really focused on these blanket rules or blanket efforts to forgive student loans, such as through notices in the Federal Register under the HEROES Act, the department continues to forgive federal student loans through the Borrower Defense to Repayment regulations. And the way it works is the student would file a Borrower Defense to Repayment claim with the Federal Department of Education and allege that the school made a substantial misrepresentation. And substantial misrepresentation is a bit of a misnomer because the regulations currently define substantial misrepresentation quite broadly. So it's actually a low standard. But the student would file a claim with the Borrower Defense Unit of Federal Student Aid, and the Federal Student Aid Unit would review this, forgive that student's loan, and then initiate a recoupment action against the institution to recover the amount of the loans forgiven. Except for I think there's a few problems with this. And I'm saying this as someone who co-authored the 2019 Borrower Defense to Repayment regulations. So I think under the current Supreme Court precedent, the U.S. Department of Education doesn't really have the authority for the Borrower Defense to Repayment scheme at all. Title IV of the Higher Education Act, as amended, states the Secretary shall specify in regulations which acts or omissions of an institution of higher education a borrower may assert as a defense to repayment of a loan made under this part. The entire Borrower Defense to Repayment scheme relies on that one provision in Title IV of the Higher Education Act. That provision does not give the Department of Education the authority to adjudicate claims, to forgive student loans, or to initiate recoupment proceedings against institutions to recover the amount of the loans forgiven. When this statute was promulgated, the first set of regulations addressed essentially defenses to repayment that a student borrower may make in a defensive posture, so in a collections proceeding. And the 1994 regulations specifically stated that these defenses may be used in tax refund offset proceedings, wage garnishment proceedings, salary offset proceedings, or credit bureau reporting proceedings. None of those allow a student borrower to affirmatively claim that they should have their loan forgiven based on the actions of their institution of higher education. And I would submit that the statute should be taken literally. Acts or omissions of an institution of higher education as a defense to repayment of a loan. So the Secretary can state what the defenses should be, but nowhere does it state that the Secretary of Education has the authority to do anything else. So with that, I think the next thing we look at is the major questions doctrine, and is this of vast economic and political significance? And I think we need look no farther than the Sweet versus Cardona settlement to determine that yes, there are vast economic consequences. And Sweet versus Cardona is a class action lawsuit started in 2019. A group of student borrowers filed these borrower defense claims, and the Department of Education did not adjudicate them in a timely manner. And the students argued that that delay constituted a final agency action under the Administrative Procedure Act such that the court had the ability to act. And the Northern District of California agreed. And this lawsuit continued until the Federal Department of Education essentially stated, we don't have the resources to adjudicate these claims, and we're just going to enter into a settlement and forgive essentially $6 billion of federal student loans. And I would surmise that that is a vast economic consequence. And oddly enough, I think the court, in justifying its decision to approve this class action settlement, acknowledged that the Federal Department of Education doesn't really have the expertise or at least the resources for the borrower defense to repayment scheme. The Northern District of California, the court stated, here's the practical litigation problem the Secretary faces and seeks to settle. The borrower defense program set up by Congress has devolved into an impossible quagmire. This has been true across all administrations as detailed above. As of now, approximately 443,000 borrowers have pending borrower defense applications. That is a staggering number. If hypothetically the department's borrower defense unit had all 33 of its claim adjudicators working 40 hours a week, 52 weeks a year, no holidays or vacation, with each claim adjudicator processing 2 claims per day, it would take the department more than 25 years to get through the backlog. So the department has a scheme to forgive federal student loans that it's using even today that it has no resources to really administer. And I think this is a problem. And lastly, I think everyone should be watching one particular lawsuit right now with respect to borrower defense to repayment claims, and that's the Career Colleges and Schools of Texas lawsuit against the Federal Department of Education. The Fifth Circuit has recently issued a nationwide preliminary injunction against the most current version of the borrower defense to repayment regulations. And the most current version is probably the broadest in terms of allowing for federal student loan forgiveness. There are different standards like aggressive and deceptive recruitment, which is defined to include unsolicited contact with a student multiple times. And by the way, these rules apply to nonprofit institutions. So if a nonprofit institution mailed literature to a prospective student, that could be unsolicited contact under the rule. And what's really fascinating is that the current regulations allow attorneys general and legal assistance organizations like nonprofit law firms to file a basically class action claim against a particular school on behalf of students without the students actually saying they want federal student loan forgiveness. And this would mean like the Florida Attorney General possibly could initiate a group borrower defense claim on behalf of a group of students at the University of California, Berkeley. So you can imagine these has some really grave sovereign immunity implications. And so this is just not a great rule, but I'm really watching for whether the Fifth Circuit will actually agree that Congress never gave the Federal Department of Education the authority to forgive student loans by giving them the authority just to promulgate regulations for defenses to repayment of a loan. And I think that the Fifth Circuit would be well within its power, and it would be unusual, but not particularly unprecedented for the Fifth Circuit to go ahead and decide this, even though the Federal District Court determined that there would not be irreparable harm, which is why the Federal District Court did not grant that preliminary injunction. But oddly enough, the Federal District Court did agree that there was standing for this. So it remains to be seen what happens with the Fifth Circuit. And now I'll allow my colleagues to talk about more interesting topics.
Well, I would like you to come to the Hill with me after this and lobby for more FSA funding. So hopefully we can do that next. But I think, I think executive power and standing are two things that are very conveniently used at one's whim, and the talking points basically flip around when we see who gets power in the White House or in Congress. And so, I'll just give you an example. Everybody likes executive power when they're the executive, and my very first Federalist Society event was during the George W. Bush administration. I came to the conference and worked on judicial nominees, and John Yoo was arguing for broad executive power to use enhanced interrogation techniques and other national security implications for that executive power. So, everybody likes it when they have it, and they don't like it when they don't have it. But when we're looking at, especially now when we're talking about a Congress that has either shown itself unable or unwilling to address a lot of big pressing issues that we're facing in the country, I think presidents have gotten even more aggressive in using that executive power to address longstanding problems. And that's a problem for the reasons that we've talked about. It results in wild policy swings, and it results in crafting weird policies to try to get around standing and all of these other things that aren't really the best way to govern the country. But I would say I think there's a big difference between some of the rule changes the Biden administration has made around Title IX, around income-based repayment, around borrower defense, and the sweeping blanket loan cancellation. When we look at the emergency powers, I don't think Congress passed emergency powers thinking that Donald Trump was going to raid the Defense Department budget to go build a border wall. And I don't think that they meant it for President Biden to wave his magic wand and do away with student loans. Both of those are not good uses of the emergency power. Both of those are things that are long-standing problems that should be dealt with by legislation, not by the pen and the phone, as we say. But for example, both Trump and Biden did choose to use emergency powers to pause payments during COVID. That seems to me much more defensible. There was a nexus to what was going on. Now, should they have kicked it out for 3.5 years? No, but at the time when we were in an emergency and we had people that were trying to figure out what to do from here, both presidents decided, okay, we're going to actually take action around student loans that is related to this public health emergency and say, we'll pause the payments. So I do think there's a difference between those two kinds of actions. And on the negotiated rulemaking that's coming up, the next version of student loan cancellation, I think the outcome is really going to be determined by how they structure that rule. Now, if they use their authority, which I think is pretty broad, to discharge loans to borrowers who have specific eligibility criteria, that's one thing, and that's where the borrower defense piece comes in. If they say, the student loan problem is a crisis, and so every single person who has student loans gets this thing, that's not specific eligibility criteria. So I don't understand how you can then defend that. And I think that, the Roberts Court has been pretty clear that they wouldn't be in favor of basically just doing exactly the same policy, but after a whole bunch of negotiated rulemaking and then putting out a new rule under new authority. So I'll put that aside. I do think they'll probably do the same policy and that it will probably get struck down again, but not before the next election, and that's really all most people who are working on that care about. But when you look at something like borrower defense to repayment or Title IX, those are issues and areas on which both parties, when they're in the White House, have regulated. The DeVos administration put out its own Title IX rule, as you mentioned, also its own borrower defense to repayment rule. So that to me signals that it's not about whether the Department of Education should have an opinion on those things or regulate on those things. You just have a problem with the substance of the rule. And that's totally fine, but then to say, we're gonna question your ability to regulate on this at all seems to me that it takes it another step that we shouldn't do. We should argue about the actual substance. So in borrower defense to repayment, as I said, I think folks are looking at borrowers who have specific eligibility criteria. There is legislation that says that you can discharge those loans in specific criteria. So the criteria differs under the DeVos rule and the Biden rule. It also differs between the Obama rule. But the criteria is what we're arguing about, not whether or not we can regulate. And on Title IX, I think the ultimate purpose of Title IX is to ensure that every American student is treated fairly in the classroom. And I think that what the Biden administration has done has been to move that definition along towards that purpose. And it is really related to some of the Title VII litigation that we've seen. In the Title VII litigation, we've seen that the phrase discrimination on the basis of sex means some things that we might not have thought it meant when that legislation was initially passed. So I think, when you look at the Supreme Court's discussions around the definition of sex and gender and how related they are, there's a clear leg to stand on. And then I'll end with the income-based repayment program, which is a big topic of conversation this week as we try to get the federal student loans started up again and people back into repayment. And there's challenges to that rule as well, and it's understandably so. It's the most expensive rule in the history of the education department, even more so than a blanket cancellation would be. However, if you think about that, I liked your phrase, clearly and specifically delegated. Congress has clearly and specifically delegated to the Secretary of Education to design an income-driven repayment plan. That's what it says. It doesn't say exactly how, and I think that's pretty clearly what they've done. They've designed an income-driven repayment plan. Again, I might not love the details. I might think it's too generous, but that is what Congress asked them to do. So now we may have questions in getting back to Chevron around whether Congress should be able to delegate that much authority, but when it comes to the tension between Congress and the Secretary here, they asked the Secretary to do this. So I think that's also in kind of a different category. But with that, I'll just open it up for you to disagree.
Jennifer.
Okay. Is this on?
Yeah.
Is it on? Yeah? Okay. All right. I'm not going to talk about standing or student loans or the Administrative Procedures Act. I'm going to talk about sex. Because that's what Title IX talks about. And Title IX, for those of you who don't know, is a very simple statute. It's 37 words. It prohibits discrimination on the basis of sex by educational institutions that receive federal money. That's it. That's our mouse hole. I don't see anything about gender identity. I don't see anything about gender. I don't see anything about sexual orientation in there. But what we have seen over the past few years is an attempt by Democratic administrations to use Title IX to socially engineer every aspect of the educational experience from kindergarten through graduate school. Now, the department would say they are simply interpreting the language. They are interpreting what does it mean to discriminate on the basis of sex. And clearly they have the authority to do that and to apply the statute to specific scenarios that aren't all delineated in Title IX. Interestingly, I mean, the things that Title IX does delineate are the exceptions. It doesn't delineate the general principle. So the agency has the authority to do that. It doesn't have the power to rewrite the statute or interpret it in a way that makes a significant economic or political shift away from how the statute has previously been interpreted. So how has it previously been interpreted? Well, this law was passed in 1972, and like I said, it prohibits discrimination on the basis of a single category, sex. In 1972, there was never any question that biology is what the term referred to. And I'll just have to disagree with my colleague, Lede, in saying that the purpose of Title IX is not to ensure fairness in the classroom or fairness for students. The purpose of Title IX is to prohibit discrimination, period. So we can try to interpret what that means, what rises to the level of discrimination, and we can also try to interpret what the word sex means as used in the statute. But what it is not is a fairness statute. It's not a federal code of conduct. It's not an anti-bullying statute. It's none of those things. It was only ever intended to protect women from being discriminated against as compared to men, or the other way around. It doesn't say that this is a statute that protects women. It protects the category of sex, which means either male or female. And the statute is constructed in a deliberately binary way. It refers repeatedly to both sexes. This would make no sense if the term sex were being used to describe a range of identities. It refers to specific men's and women's organizations when it talks about some of the exceptions. And it talks about how the membership of certain organizations like fraternities and sororities have traditionally been limited to persons of one sex. And it prescribes that if opportunities are provided for students of one sex, opportunities for reasonably comparable activities shall be provided for students of the other sex. So it talks about both sexes, opposite sexes, other sexes, meaning two. Now, does that mean that Congress can't, if it wants to, pass a statute prohibiting discrimination on the basis of gender identity? Congress is absolutely free to do that. In fact, the Equality Act and several other pieces of legislation have been introduced. Congress has decided, in its wisdom, not to move forward with those statutes right now at this point. Maybe someday it will. As of now, it has not done so. So where does the department find its authority to say that Title IX now protects discrimination on the basis of gender identity? Well, the department is relying essentially on the Bostock case, which dealt with discrimination under Title VII. And in that case, the court held that under Title VII, which has similar language, it says because of sex instead of on the basis of sex, the court held that if an employer treats a man who presents as a woman differently than it would treat a woman who presents as a woman, that the employer has discriminated on the basis of that employee's sex. So it was very specific. It didn't say that it was redefining sex or interpreting sex to include gender identity. It said it was interpreting the part of the statute that describes what the discrimination is. It was very clear to say that the ruling was limited to Title VII, and I think with good reason, because in that context, they were dealing, even under Title VII, they were dealing only with basically hiring and firing decisions. Title IX, and they were dealing with basically employees that were similarly situated, right? They were looking at, would the employer have treated the same employee doing the same job differently if they were a woman? And the court said yes. In the Title IX context, there are many situations where we're not dealing with similarly situated students. When it comes to athletics, when it comes to bathrooms, locker room uses, sharing dorm rooms, men and women are not similarly situated. And specifically with respect to athletics, sex is not only irrelevant, it's dispositive. So both sex reasoning is really completely inapplicable here. And so I would argue that the whole gender identity thing is, a clear elephant that they're trying to shove into this mouse hole of the phrase on the basis of sex. With respect to the major questions doctrine, I would argue this is a major question. It impacts potentially every child in the country, or the vast majority of them who attend schools that take federal money, which is most of them. The fact that it will affect that many students or that many people was relevant in the OSHA case. I think it's relevant here. It is not as economically significant as perhaps the student loan case, but I would say that Title IX is a spending clause. It involves the distribution of large sums of federal money to schools, and basically Title IX is being enforced under the sword of Damocles and the threat that this money is going to be taken away. So potentially, it does have a significant economic impact. So the long and short of it is that without a clear statement from Congress saying that Title IX requires the accommodation of trans students in certain ways, they cannot use Title IX to do this. I welcome Congress to take it up, and we'll have a debate about whether and in what circumstances it makes sense to do that. But this statute, I believe that any attempt to shoehorn gender identity into Title IX does raise major questions and is an abuse of executive power.
Thanks to our panelists. We're going to now move to the response section. We're going to go in the same sequence. I'll note for our panelists it'll probably have to be less than 9 minutes each as a result of where we are. We're going to begin with Professor Sugarman. There has been some discussion of emergency power. I did want to note that in the Biden versus Nebraska oral argument, Justice Kavanaugh asked about your amicus brief, Professor Sugarman, on emergency. You might want to fold that in. Your thoughts?
Oh, sure. Thanks for that. Thanks for that invitation. I'll take any invitation to talk about how a Supreme Court justice quoted something I wrote. Even if I want to note, it was interesting that, so what happened was Justice Kavanaugh asked, just so happens I have that passage right here, Judge Brennan. Justice Kavanaugh said, last question, broadening it out and thinking about it, you mentioned emergencies. This was to the Solicitor General Preligar. The history of the court with respect to executive assertions of emergencies. Some of the biggest mistakes in the court's history were deferring to assertions of executive emergency power. Some of the finest moments in the court's history were pushing back against presidential assertions of emergency power, and that's continued not just in the Korean War, either the steel seizure cases, but post 9/11. So given that history, and there's a concern, I suppose, that I feel at least about how to handle an emergency assertion. You know, some of the amicus briefs, one of them from a professor, and I don't want to say that I agree with this professor. I'm just saying the assertion about emergency power, and I want to get your assessment. This is a big picture question, so I'll give you a little time. How should we think about the role of presidential emergency powers given the court's history? So one point is, well, that was exciting, but it never wound up in the opinion. And now let me say about, I presented this paper last week at Scalia Law School and the Boyden Gray Center, which has been an amazing roundtable with a broad spectrum of administrative law scholars. I was reminded by one of the attendees there that things are chaotic at the end of a court term. But I think there is a problem with the court making so much law without being clear enough about it. And so this was in front of the court, and it was disappointing that the court identified this in oral argument and then I think exacerbated the problem or overcorrected, right? Or is going to have to in the next emergency undercut the court's legitimacy by playing politics about which assertions of emergency power the court likes and which one it doesn't like. In a podcast by left-wingers, that part of the oral argument was played, and the three liberal podcaster law professors called this line of questioning, quote, insane, unquote. I don't think it's insane, right? I think it might be prescient if there is going to be this next battle of emergency power. So I just want to emphasize that, and I think that, and I would think all the panelists would agree, and I think specifically Mr. Corrigan and Ms. Erickson identified, it depends upon whose ox is being gored. That's not law, that's politics, right? We need, if I'm a rule of law person first, we need to be thinking about how the Supreme Court needs to step back from picking and choosing which major questions it likes. And I say this as someone who agreed with King versus Burwell when it came down, and now I realize if I can't teach it as rightly decided, maybe it wasn't rightly decided. King versus Burwell, I would say as someone who actively supported the ACA, I think King versus Burwell was wrongly decided. Let me just pivot to, I think, a question for Ms. Thompson, and then a question for Ms. Braceras. Ms. Thompson, you said that under the borrower defense to repayment, the secretary can state what the defenses are but can't do anything about it. I'd just like to get, I'm curious about if the secretary has a power, what you think why that limits the delegation, and specifically because under the Higher Education Act of 1965, now this is limited to I'm sorry this is going to get student debt nerd into the weeds, but this is only for Part E Perkins loans. But 20 U.S.C. 1087 HH says that the secretary has the power to, quote, enforce, pay, compromise, or waive any right, title, claim, lien, or demand, however required, including any equity or any right of redemption. In the canons of statutory interpretation, we have something called the any, it's not just any canon, it's called the any canon. There are words that Congress uses to signify sweeping powers, setting aside the non-delegation problem, as Ms. Erickson identified. It does seem like this is a very broad and clear delegation, at least on Perkins loans. And then when you, on settlement and compromise, the Treasury Department has 4 regulations that are very broad, where Congress apparently delegated a lot of discretion on repayment, including one of the regulations on the ability to repay. So, I mean, we can ask, and if one wants to look up arguments for non-delegation, I have written an article called Vesting, which is chiefly an argument about the misuse of Article 2 vesting clause. There is no evidence that vesting meant anything indefeasible, and so I filed a brief in SEC versus Jarkissi on the question of removal. But the flip side, I say in my article, is on non-delegation, the phrase all legislative power, and don't just take my word for it, Gorsuch and Thomas have also italicized the word all. That's not in Article 2, but it's in Article 1. I'm sorry, this is a non-delegation rabbit hole out of a mouse hole, but if the words of the Constitution matter, it turns out that when you look up the uses of the phrase vesting in the dictionaries, there's nothing about indefeasibility of the word vesting, but when you add the word all, it reflects the way that our founders in databases of their uses of the word vesting differentiated between simple vesting, the use of word vesting by itself, versus fully vested or all powers vested. And on the other hand, General Washington often used the word partly vested because it was the way that one delegated authority in a limited way. Well, if Article 2 did not only said the executive power shall be vested in the president, but Article 1 says all legislative power herein granted shall be vested in a Congress, I think that's an argument that they meant more strongly vested and less delegatable. So the final question for Ms. Braceras on the question of discrimination on the basis of sex, I understand where you're coming from, that Bostock is not binding, but I think it's a stretch to say that the Bostock analysis is completely inapplicable. I mean, but I'll say the flip side is be careful what you wish for with textualism. I mean, I agree with your, I would come out the same way in Bostock, but for different grounds. But I think your critique of Bostock or applying Bostock is a critique of textualism as much as it's a critique of Bostock.
It's a critique of literalism.
It's well,
It's
or if, I would say that it's a strong. I would agree, but I think some of your arguments sound more like purposivism against Bostock than they sound like clear textual distinctions, because Gorsuch has a textual argument.
Let's first start Farnaz, and then we'll go to Jennifer. Farnaz, your response to
Sure. Well, if I will go into the weeds with you. So the borrower defense to repayment regulations are under a specific section of Title IV that deals with direct loans. So the William Federal, it's the direct loan. So when you're talking about Perkins loans, I don't necessarily think we can say what was true for Perkins loans is going to be true for direct loans. So that's
I agree.
And then the second, just the second point is that the remedy here is that if an institution is making some kind of substantial misrepresentation regarding the employability of its graduates or the nature of its educational program, the remedy is to either suspend, and this is what the statute says, you can suspend or terminate the eligibility of that institution to participate in the federal student loan program, which is a lot more drastic of a remedy than just forgiving someone student loans. And so what you're pointing out, and there are sections, let me be clear, there are sections of Title IV that refer to canceling, modifying, discharging federal student loans, and you have to be really careful whether you're talking about the family or the federal family education loan program, FEL loans, Perkins loans, direct loans, and I'm sorry I'm getting into the weeds, but you did bring up this one section about Perkins loans. So when we're talking about relying on one tiny provision that gives the secretary the authority to promulgate defenses to repayment, and it doesn't say in that section, and that's all we're relying on for 4 separate sets of borrower defense regulations. We're just relying on one little section that doesn't use canceling, modifying, discharging. And those words are specifically used with respect to other loans, like Perkins loans and other sections of Title IV. I think it just strengthens the argument that Congress never gave the Secretary of Education the authority to adjudicate borrower defense to repayment claims, forgive student loans, and then to initiate a recoupment proceeding against the institution to recover the amount of the loans forgiven. And I think the Department of Education has actually been clear that the statute is not what gives them the authority to initiate a recoupment action against a particular school. It's case law, which I don't think that's a great argument, and I don't buy into that. Because what would the Federal Department of Education do if it's, for example, trying to forgive federal student loans against one of the college systems of a state? That would be a lawsuit against a state, and essentially I don't think it would be permissible under the Constitution. So I think that there are several issues with the Borrower Defense or Repayment Program. I think the provisions that you cited, there are similar provisions regarding other types of loans. And that is now what the Federal Department of Education is trying to do. So the Federal Department of Education has to go through what's called negotiated rulemaking to promulgate regulations under Title IV. And the department is now going to try to forgive loans in a massive way through negotiated rulemaking. But it first has to go through negotiations, then it has to issue a notice of proposed rulemaking, and then it has to issue final regulations by November 1st for those regulations to become effective by July 1st. So there's a long process, and it's unclear. I think it remains to be seen, and I think even the General Counsel's memorandum for the Federal Department of Education under Secretary DeVos had a little, we don't think this is possible, but if it is, you have to go through negotiated rulemaking, and it has to be done on an individualized basis because each individual student's experience is different, and the representation made to one student may differ than to the representation made by another student. And I think we have to be really careful here because there are a lot of, and I see this, there's nonprofit schools, and they also make misrepresentations, and they get sued, and there's judgments against them. But this borrower defense or repayment scheme has not been used against the nonprofit schools traditionally, even though the regulations apply equally to all. And so I think we just have to be careful when we go down this slope as to what the parameters are and what exactly Congress authorized.
Jennifer.
So I wasn't so much critiquing Bostock. There's no point in relitigating that here. What I was trying to do is explain why the analysis in Bostock doesn't work with Title IX. It's a totally different statute. It's a spending clause measure. It is explicitly binary in the language that it uses. And most importantly, the context of the things that it regulates are different. And so, as I said before, it's not just dealing with similarly situated people that might be being treated differently. You're dealing with people, contexts where schools might be separating men and women because of real biological differences between men and women. And I would add, with respect to Title IX, is that if Bostock is applied to a couple things. If Bostock is applied to Title IX, as the proposed regulations attempt to do, it sets up a direct conflict for schools where they will always be in violation of Title IX with respect to sports, because it is impossible for schools with limited budgets and roster spots and scholarships to allow a male who identifies as a woman to play sports on a women's team and still provide equal athletic opportunities for women. Okay, unless they're going to add another roster spot, they could add another roster spot, but arguably every time that male-bodied athlete hits the field, that takes playing time away from a female athlete. So in order to comply with the Biden administration's rule, and I acknowledge there are two rules. There's the general proposed rule that tries to stick gender identity into the mouse hole, and then there's the other rule that deals explicitly with sports. And we could talk about that, but even without the rule that explicitly deals with the granular level of sports, the gender identity rule applies to all aspects of education, including athletics. So my comments are relevant to both. Anyway, yeah. So I just don't think Bostock applies to Title IX. I think if the courts were to go along with that, I think it would do grave damage to the statute. I guess that's the main thing.
Lene, let's get you in here.
Thank you. I'm pulled in two different directions, but let me try to do both very quickly. I think on the borrower defense piece, you noted that the Department of Education is essentially the lender in this scenario. And we're talking about conduct that has violated either federal or state laws that these institutions have committed. Now, I would be delighted if they would close those institutions down. Those institutions also have really good lawyers, and so that's all in litigation all the time too. And that would be a great piece of it, but then you also have to deal with the fact that you have consumers that have been defrauded, and if the Department of Education has been given so many different places explicitly in law that says you can waive, you can change, you can do this because you're the lender, it's your money that you're lending out, then it seems to me that it is very, very reasonable to say for people that have been defrauded, that is a specific criteria in which you can say this group of students is a class that has been defrauded. So say you're all the same ITT Tech class that all saw the same advertisements. Why should you each person need to go and prove what was in that advertisement or who the people were that wrote that advertisement? That doesn't make any sense. That's not how we work in class actions. When we have a class action, a group of people is treated the same. It should be here too. But let me do quickly a piece on the Title IX rule. I think, just stepping back on the major questions piece, we're talking about the student loan cancellation was what, 46 million people and hundreds of billions of dollars. If we're talking about the Title IX worries that you're expressing, we are talking about a tiny handful of cases that have been brought up and have had, a lot of media attention where we are talking about competitive athletes. So that to me does not, like whether Leah Thomas can swim is not a major question that should be addressed by the Supreme Court. It's just not to the same level of systemic political and economic significance. But I'm glad to see you acknowledge that actually the Title IX rule did separate out sports. It said because
It says it did.
Well, but the purpose of Title IX is, in my view, is to ensure that people are not discriminated against in our education system. And we know that where someone's rights butt in on someone else's rights, then we have to have a more nuanced conversation. And that is what's happening on sports. In sports, the Biden administration said, we're setting that aside and we're going to make a different rule because there are things around fairness and safety that we need to discuss. And so we don't think that a school district should make a blanket ban because these are nuanced decisions. And it's probably different to talk about a 5-year-old that's playing kickball versus Leah Thomas, who's competing in in an NCAA tournament. There are differences there, and we should acknowledge that. And so I think the Biden administration should get some credit for saying, okay, this is a harder and more nuanced thing, and we're going to actually address it in a different way. So that to me makes it very different. But I think the Bostock comparison, Gorsuch said that sex, the word sex plays a necessary and indistinguishable role in being discriminated against on the basis of sexual orientation and gender identity. That's in the workplace. This is in schools. I really don't see how those are so different that obviously it doesn't directly apply, but the same principle applies pretty obviously to me in most educational contexts, with the sports piece being a more nuanced conversation.
Christian.
So that's actually a great segue. Getting back to what I didn't get to the first time, which is the economic and political significance of a particular rule. So let's start with the political. I don't think there's anything over the last 2 years that's obtained more political significance than the transgender issue. Ask Bud Light, Disney, or Target about that. And the West Virginia EPA, talked about several $billion a year in compliance, about abolishing an entire industry. It's true that Biden v. Nebraska was hundreds of billions of dollars in loan forgiveness, but all right, so Title IX is a spending clause statute, so there's a direct impact on the loss of federal funding for states. And it's 21 states have laws banning biological males from competing in women's sports, which would violate both of the proposed Title IX rules. So it's some part of 17,000 school districts, 4,700 higher education institutions, 18 to 20 billion a year in grants to state educational associations. So I think that it does satisfy, particularly as it relates to the sports issue and the issue of the issue of locker rooms, things like that. But I do think that what's interesting is, and the court hasn't said anything about this yet, but the major questions doctrine might make the spending clause more of a two-way street. And in that, I mean, the more funding the federal government attaches to a program, the more likely that it is to become a major question. The spending clause cases that are concerned with coercion and the metaphorical gun to the head of states, I think are quite interesting. Couple things I want to touch on. I do think it is interesting how far we've come. I came across a blog post from March of 2017 from the National Women's Law Center on the Gorsuch nomination, which lamented that Justice Gorsuch's hostility to Chevron deference might prevent the experts at the Department of Education from protecting women's sports. And so it shows you sort of how far we've come in this debate. But one quick thing on state standing. I think the professor and I have pretty strong views on state standing. I will say that one thing we didn't talk about on the downside of that is the Braceras decision, which is the Indian Child Welfare Act decision. In a decision by Justice Barrett, there is sort of a disappointing passage in there where the state of Texas tried to get involved in the case, and Justice Barrett, sort of in a drive-by line, shot down the idea that states have what's called parens patriae standing, which is a form of third-party standing from common law that allowed the king to step into the shoes of his subjects and assert their rights. States do that all the time, but there's a case from the early 20th century in Massachusetts v. Mellon that says, well, states can assert parens patriae against the federal government, so that put that to rest. But even more disappointingly, Justice Barrett also said that just because Texas argued that ICWA conflicts with Texas law and would force Texas's agencies to violate their own law, that itself was not a concrete injury for purposes of Article 3. So a little bit disappointing there. Now, I will say, as far as parens patriae goes, there's a great decision out of the Sixth Circuit in Kentucky v. Biden, which is the federal contractor mandate, where a decision, I think, written by Judge Bush that says, well, when states assert parens patriae, they're not really always asserting an injury on behalf of their constituents. They're sometimes actually asserting an injury to their own quasi-sovereign interest in similar to public nuisance cases. There's a time when they're really going after their own interest that's being affected, and I think that is similar to the state standing we were talking about, say, in Nebraska v. Biden. So.
Can I jump in and just say one thing? With respect to the question of whether or not Leah Thomas swimming is a major question, I certainly don't think it is, but I want to explain why, if we apply the Bostock reasoning to Title IX, it'll affect many, many more people. And that is because Justice Gorsuch applied a but-for test. And so using a but-for test, anytime an employer thinks about the sex of the person and the sex is relevant to the decision-making, it's a violation. It counts as, it's discriminatory if the decision is being made because of sex, or, if it would be made differently but for sex. So if you apply that to sports, every time a male lacrosse coach, or not just a male lacrosse coach, a lacrosse coach says that a male player, trans or otherwise, can't try out for the women's team, they are making a decision that would be different but for the sex of the player. So 99% of the time, if you have a male Division I lacrosse player who gets cut from his team and goes to try out for the women's team, he's going to be way better than all the girls on the team. And so he's going to be qualified to play, and the decision not to let him play can only be made but for sex. And if we're taking Bostock and applying it to this very different context and very different statute, it can only mean that we will no longer be able to offer single-sex sports to anyone. So think about that.
We've covered a lot of ground. We're going to move now to questions, so feel free to approach the microphones if you've got certain a query you'd like to pose. If you could state your name, your affiliation, and then If it's particularly to a specific speaker, please say who. Otherwise, if it's to the panel, you can name that as well. Bye.
Mike Donnelly, to Mr. General Christian Corrigan. You said quasi-sovereign. Can you clarify?
Yeah, so the court interestingly enough, even in the parents patriae cases and in Massachusetts v. EPA, says that states have a quasi-sovereign interest in a number of things, which is their territory, their air, their land. I think I would argue, again, that they have a quasi-sovereign interest, perhaps a sovereign interest in seeing their laws upheld and defending them. But that's what's really interesting about the sort of death of parents patriae, is that the overlap between that and the language and the rhetoric that was used in Massachusetts v. EPA has really confounded many of us in the state AG world. I think it's confounded a lot of federal judges that we've been in front of. And so, yeah, it's a term of art, and I wish I could tell you I know exactly what it means. I just know hopefully it's good for state standing.
Go here.
Thank you. My question is for Ms. Braceras,
Could you move a little closer to the microphone? Thank you.
relating to Bostock. Isn't it true that Plaintiff Stevens in Bostock was a biological male identifying as a biological male, and that his claim was tethered to the fact that he was a man wearing women's clothing and not that he was a man that identified as a woman? And wouldn't that impact the application of Bostock to Title IX?
I'd have to go back and look. My understanding was that he was, the plaintiff was trans-identifying, but that the attorneys made a lot of their arguments to try to fit with stereotype discrimination, and they tried to fit it into that box. But so, regardless, the decision itself was based on the fact that the employer treated a man who either identifies or presents as a woman differently than a woman who identifies and presents as a woman. That's what it was based on. So I don't think that's dispositive.
Thank you.
Yeah, I'd like to just add one thing. So with respect to Title IX and employment, even the last administration issued a Q&A guidance stating that with respect to Title IX and employment, because Title IX also employs, also applies to
Teachers
employment, that would be potentially an application of Bostock that applies. So even under Title IX, you wouldn't treat a transgender person differently with respect to employment.
Yes, correct.
I do, and I think Justice Gorsuch was really clear in the majority opinion that his ruling did not apply to locker rooms, bathrooms, intimate facilities. So he drew a line, and the majority, and he was joined by the majority of the. I'm having issues with mics, but. So even Justice Gorsuch and Bostock drew this line. So I don't think we can say that Bostock requires such a ruling or such Title IX regulations. And I think that the fact this administration is having kind of a separate rulemaking on Title IX and athletics acknowledges that there are different considerations. And the initial regulations with respect to Title IX and athletics were actually promulgated after the Javits Amendment. So I don't know how many people remember this, but with respect to the Javits Amendment, the regulations for athletics had to actually be approved first by Congress before they actually became effective. And that's the opposite of what happens with most rulemakings. The final regulations for most rulemakings become final, and if Congress doesn't like it, Congress has the Congressional Review Act to essentially undo those regulations. And lastly, I'd like to say, even if this Department of Education never issues Title IX regulations on athletics, once it changes the definition of sex, the current regulations that exist will, by virtue of the definition of sex being changed, just have a different application. And I think it's what I thought was really interesting about the proposed Title IX regulations is that the department never quite defines sex. It doesn't say sex is this. It says sex includes these categories, but it never draws a baseline for sex. And I think it's really hard to understand what sex means when there's no baseline definition, but it includes certain categories. And so I think to improve upon the department's definition of sex, it'd be nice to have a baseline in the final rule.
Just to jump in on one point there, I think it's not just about what are you being discriminated on the basis of, it's whether there's discrimination in the first place is part of all of this, right? And discrimination is when you're using a characteristic to judge someone where it should not be relevant. And I think we're having a different conversation about where it should not be relevant for making sure that people are safe and not discriminated against in schools versus should there be some relevance to it in the sense of competitive athletics? Let's have that conversation. But I think that's a different conversation, and that's why I don't think that taking the lessons of Bostock would be the end of sex-segregated sports, because there are circumstances, even in hiring, where you are allowed to take into account gender or other
That's because Title VII has a BFOQ exception, which Title IX does not. And if it did, we wouldn't necessarily have the problem, but it doesn't, so.
Let's go to a question over here.
Yeah, so I'm noticing a lot of different identity shoehorns into civil rights legislations. I'm wondering the extent to which those civil rights legislations are based upon the 14th Amendment, and the extent to which turning the 14th Amendment into a free-for-all, contrary to its original intent, is actually creating the problems that we're having today. And to the extent that those of us who are interested in originalism might hearken back to, in our argumentation, the original intent of the 14th to get that clarified, even though we know the first sentence says exactly what it's for, but we seem to have forgotten that. Thank you.
I'm happy to, I'm actually on a panel at the Cato, and I'm presenting this paper at Cato. My co-panelist is David Bernstein, who's defending the UNC and Harvard results. And I'll just put on a historian's hat and as an originalist as well, one of the problems that goes unaddressed in that opinion is that as a matter of original public meaning, if the statutes matter, and there is a lot of inconsistency about this, the Reconstruction Congress that passed, that drew up and drafted the 14th Amendment that was then ratified by the people, in the same Congress they drafted legislation, this is in the dissents, refers not just to freed people, which would be a neutral racial category, at least formally, but also drafted several statutes that referred to benefiting, quote, and this is their language, not mine, quote unquote, colored people. Now, this is a big problem. Now, I'm not saying it's dispositive, but if you're going to be engaging in originalism, you at least have to have an answer to historical evidence. And I'm not saying what the right result should be. I think it's a hard question, but I think we're in a jurisprudential crisis right now. That jurisprudential crisis is whether originalism is being applied. I'm an originalist in theory. As I watch the court keep taking decisions and cherry-picking which evidence it likes based on ideology, I have concerns about originalism in practice, which is why I filed a brief in a case coming up this term called SEC versus Jarkissi, because I think the unitary executive theory is ideology, not history. So this is a broader, I think you're raising a broader, one of the biggest questions in law right now, which is what is the legitimacy and the even-handed applications of methods rather than the application of political and ideological priors.
Question.
So, David Tryon with the Buckeye Institute. Professor Sugarman had a question for you when you're talking about the major questions doctrine and the clear and specific statement rule that you talked about. And you said this would handicap the executive on responding to emergencies. So my question is, but why is that bad? If it's truly an emergency and the response to it is so obvious, then Congress is going to act pretty quickly and deal with it. They'll come together and they'll handle it instead of having this dictatorial type response that we saw with COVID, which turned out to be significantly wrong in many respects. And we look back in history, as you mentioned, to some other emergency responses that turned out to be completely wrong. Of course, military responses, the commander-in-chief has the ability to respond to those, but all these other, I'll just call them pseudo-emergencies, are just used as opportunities to accumulate more power, it seems to me. So why is it a problem?
The historian in me agrees with everything you said, right? Because after 9/11, how did Congress enacted legislation that was direct, that was clear and specific. After the 2008, 2009 housing crash, whether it was TARP or in the early Obama, at the end of the Bush or early Obama administration, Congress acted. COVID, Congress acted. That's true historically. But I also have to ask, in terms of the history of Congress, I'm concerned that Congress is so dysfunctional that there are going to be future crises that need some middle ground. So this is why this is why I agree with Biden versus Nebraska on the result, is that there had to be a correction. I agree with, let's say, 90% of the direction it went. I just think that there is going to be a gap that where our dysfunctional Congress with filibuster rules is going to hamstring administrations. But you raise a very good point. Point well taken.
A major questions doctrine for Congress, huh? Okay. Any further questions that we have? Please join me in thanking this excellent panel.
I think that we're assuming Congress can do things when we're about it.
Judge Brennan and our panelists and all of our speakers who have shared their time and talents with us today. We'll now have another 15-minute break and meet back here at 4:30 for a closing address from Governor Mitch Daniels.